Good morning. Today, for the purpose of All India Bar examination as well as judicial examinations, I would like to discuss Code of Criminal Procedure 1973 code. And all these subject-wise preliminary discussion only, and probably senior advocates may think that this may not be uh, convenient or suitable for discussion, but however sometimes it happens that when we recollect certain sections that may subsequently feed our faded away memories. I hope you understand. Here is also today actually what happened. Code of Criminal Procedure 1973 for what? Earlier there was 1898 Criminal Procedure Code, Colonial Act was there, and the entire proceedings were totally different there. But maintenance case 125 CRPC available at present Code of Criminal Procedure were available in the earlier Code of Procedure Code. The Article 226, which is now incorporated in the Constitution of India for issuance of writ of habeas corpus, there was a provision in 1898 Code of Criminal Procedure what all are the grounds to issue habeas corpus, writ of habeas corpus. So these things I want to bring to your notice, and drastic major changes between Code of 1898 Criminal Procedure as well as 1973 Criminal Procedure was that earlier under 1898 Code of Criminal Procedure, the remand is being carried by divisional magistrate, not by judicial magistrate. The remand is automatically be done by the executive authorities. When I was arrested during my college tenure of agitation, 1974. January 4th, I was remanded by Deputy Commissioner of Police and Commissioner of Police only. That provision, because that lacks of judicial intervention, the 1873 Code of Criminal Procedure incorporated the remanding power only with the judicial magistrate. So that is the drastic changes. And so many other things are available. Preliminary, I would like to discuss with you about this. For your kind information, when I studied law first year at Ravi Shankar University, Surana Law College, Durg, I was taught 1898 CRPC only. Then subsequently, since I have been transferred from Chhattisgarh to Nagpur, then I went persuaded second year and third year at Nagpur University College. There was a amendment. There was the 1973 CRPC was brought into force. Therefore, my subject was changed, and again I have been forced to write examination on that paper also. Okay, the 1973 Code of Procedure came into force on 1st April 1975, but according to my knowledge and information, in Tamil Nadu, this act, this 1973 CRPC was brought into force very off late. Then the main provision, there are section 2 deals with what all are the definition of bailable offences, about what is charge, then question of what is cognizable offence. Cognizable offence means authority to arrest a person without a warrant, that is cognizable offence. And subsequently, see, these things are on letter and spirit of the Code of Criminal Procedure Code. These things, that authority to arrest a person without warrant if any commits cognizable offence, that is slightly diluted because of time to time periodical judicial precedents declared under Article 142 by Supreme Court of India. Because of this Arnesh Kumar case and other cases says that arrest should be avoided. All those things are there. Or if you want to arrest, you should give reasons. those things may not be available under this uh, Code of Criminal Procedure. But when several guidelines were given in one particular case, subsequently those guidelines, directions, judicial ratio decisionality were incorporated by amending the Criminal Procedure Code. Then you can the code of, if you want to know what will be the available of what is the section under what category, whether that particular section punishable section, not definition class. There should be difference between a definition class as well as punishment class. You have to only refer punishment class. 378 deals about definition of theft. Punishment class running from 379, 380, 381 and so on. So to understand how to know whether that particular offence is cognizable or non-cognizable, bailable or non-bailable, or summon case or warrant case, you must go to schedule of the Code of Criminal Procedure, which is available after the last section of Code of Procedure. There shall be a schedule which described every offence, whether it is cognizable or non-cognizable, bailable or non-bailable, and so far whether it is triable by magistrate or session judge. So far summon cases and warrant cases are concerned, that is separately defined how to decide it. So the most important word under Code of Criminal Procedure is complaint. The definition of complaint under section 2D is most vital aspect to be understood. That should not be understood in a literal way or practical way. When we claim that I lodged a complaint to a police station, that is only information. That will turn as a complaint when the police, after completing investigation, files final report under 173 CRPC, and the court takes that final report for cognizance of particular offence under 190 CRPC, that is complaint. So this must be understood. I hope you understood what my endeavor to make the young lawyers to understand this. Then the question of most important aspect I would like to discuss with you was 154 deals with the registration of FIR if the information discloses cognizable offence. If it did not disclose cognizable offence, the concerned police officer may ask the informant or complainant to go to court and get order. Then if you go to court and get order, that provision is 155 and 156 class 3. The magistrate can again send a direction to register the FIR even if it is non-cognizable offence. But the investigating officer will have power of investigation as if he registered a FIR for cognizable offence, but except power to arrest. That is most important. So you have to go through 154, 155, 156 class 3, all these things. I think I have covered all for time being, and I will come again tomorrow, day after tomorrow, for rest of the cases.